Good afternoon. My name is John Culhane, and I'm a law professor at the Widener Law School in Wilmington, Delaware. And I'm here to tell you what you want to know about the Supreme Court arguments in the marriage cases next week. And there are 2 days of arguments. On the first day, next Tuesday, the court is going to be considering an argument about Proposition 8, which is the law in California that bars same-sex couples from marrying. And on Wednesday, they're going to consider challenges to the Defense of Marriage Act, which is the federal law that says no matter whether you're married under state law or not, your marriage does not count for federal purposes. So those are the two arguments, and those are the two laws that are being challenged, and it's just really a coincidence that they both come before the Supreme Court at precisely the same time, right? You might have thought that the timing would be different, one would get there before the other, but the stars lined up so that the court has agreed to hear both of the cases. And what's at stake in the two cases is quite different. So let's start with the Defense of Marriage Act case. The Defense of Marriage Act really is quite limited in this sense. All it does, although it's a big all, is to say that even if you're in a same-sex marriage from, let's say, Massachusetts or New York or any of the 10 or so states that allow it, that your marriage doesn't count for federal purposes. And so what the court is going to consider is whether Congress can decree that state laws can be ignored in terms of marriage when federal benefits are at stake. And it's unprecedented. This has never been done before. So the court is going to be considering something that really looks on one level like a pretty clear violation of equal protection. And the Proposition 8 case is a much broader case. And there's the case, where California voters in 2008 approved Proposition 8, which took away the rights of same-sex couples to marry, which the California Supreme Court had declared were required by that state's constitution. And so now the question is whether the voters can do that, or whether doing so violates the federal constitution, in particular, again, the guarantee of equality. So Prop 8 is potentially a lot broader. If the Supreme Court rules on it in the broadest way, what they could end up saying is that all the states have to grant marriage licenses to same-sex couples on the same basis that they grant them to opposite-sex couples. And here's a little twist at the end of the two cases. It's useful to think about this. It's possible the court could throw both of the cases out on the grounds that none of the parties have standing to appeal. It's a complicated legal question that only a law professor could love. But it's a little warning that when the decision is handed down in June, we might find that we're no closer to resolving these issues than we were. I will say I think that's very unlikely, and my guess as to what's going to happen is that the court's going to declare the Defense of Marriage Act unconstitutional, and will do something of a compromise with Prop 8, but we'll have to wait and see. Thanks.